We have one final request. You will receive a session evaluation after the webinar. Please take 5 minutes to complete it and send it to us. This webinar is funded by the United States Department of Justice, Bureau of Justice Assistance. Thank you for your participation. Please welcome Program Manager of the ARC's Justice Initiative, Leanne Davis, for some opening remarks.
Well, hello, everyone. We are very excited to have you back for our webinars, or perhaps this is your first time. Either way, we're very excited about this webinar today. This is actually the 17th webinar that the ARC's National Center on Criminal Justice and Disability has provided since we began this in January of 2014. So we have many other topics of our webinars that is available on our website if you'd like to go back and look at those. I want to first of all start off by thanking our presenters today. We've got Heather Sachs with the National Down Syndrome Society and Patty Saylor, mother of Ethan Saylor, who will be talking about legislation in Maryland. And then also Darla Stewart and her team there in Colorado, who will be talking specifically about hearsay exception legislation. So thank you so much to our presenters. And I want to get started just by providing some context around why this topic on legislation is so important right now. Some of you may have seen this blog post, the Huffington Post blog, that we actually provided on our Facebook page that speaks to this overdependence in the criminal justice system, specifically related to people with disabilities. In order to break the arrest cycles and end inappropriate criminalization of people with mental illness, we need to provide this community-based support. And it's not just people with mental illness, but also people with intellectual disabilities. And if we talk about why, is this emphasis on criminal justice reform going on right now, it's important to look at the history of that and realize that laws such as 3 strikes, you're out, that created this overcrowding on prisons and jails have really created this situation where we have to look at other alternatives. There's also been this rise of citizen-police interactions around videotaping, and we've seen police use of force go up. We've seen in terms of us seeing it more in the media. And this has really created a true concern among society about how often these kinds of situations are happening. And then some of you may have seen the Making of a Murderer documentary that showcases Brendan Dassey and his coerced confession. And this is a person with intellectual and developmental disabilities who gave a confession that looks clearly coerced in the documentary. So it's not only in the general population, but also we're seeing more media accounts within the population of people with intellectual disability. So this is all sort of culminated into the President's focus on this issue as well. And he has the Task Force on 21st Century Policing that created a report around these topics. Now, one of the issues is that the focus has not been on both mental illness and IDD when you look at brain-based disabilities, but the focus has been more on mental health globally. So we're trying to look at ways that we can focus also on intellectual and developmental disabilities in these reform measures. Another issue is bipartisan coalitions. We've seen this happening more at the federal level, where there is focus on reducing mass incarceration through sentencing reform. And so we see these positive changes going on. But what we're really concerned about is making sure that any kind of criminal justice reform is inclusive of people with intellectual and developmental disabilities. And these are some of the areas that we're looking at. We want to ensure that any kind of reform supports quality education and training for law enforcement. So we're excited to have the Maryland team on today to talk about legislation going on in Maryland. Also ensuring that individuals with intellectual and developmental disabilities have the access that they need to any kind of sentencing reduction programs. So when and if the criminal justice reform measures are passed in Washington, we want to make sure that people with IDD are included in any of those measures. And then we need a way to better identify people with IDD in all stages of the criminal justice system, whether that person is a victim or a suspect. And these are some really key areas that we're looking at. And again, I want to emphasize, and that is why we invited the panelists that we have today, I want to emphasize that we want to look at both victim and suspect offender issues and the legislation that is impacting them. And so I want to turn it back over to Heather, who's going to talk to you about this really exciting next step of all of this, which is creating a criminal justice and disability legislative database that will begin housing the different types of state legislation affecting this population specifically throughout the country.
Thanks, Leanne. It's actually Ashley. We are so thrilled to announce that NCCJD's Criminal Justice and Disability Legislative Database is officially being launched today. As you know, if you've followed NCCJD, this is something we've been working on for a while now, so we're happy that it's getting off the ground. It's basically we have compiled all the current laws involving IDD in the criminal justice system for your use. It will allow users to find out what the law is currently in their state, or if one even exists on a particular topic, and see how laws on similar issues vary among the states. When all is said and done, you'll be able to look it up by category of legislation or by the state. The legislation falls into 5 primary categories: competency and insanity, which deals with either the capacity to be tried or the capacity to know what they did was wrong at the time that they did it. The second is any special rules or miscellaneous rules in the criminal justice system in that state. 3 is sentencing, including any mitigating factors that would make a sentence lower or any aggravating factors that would make a sentence higher, such as a hate crime statute. Number 4 is the death penalty. And number 5 is post-conviction, which has everything that happens after sentencing on. So any special prison parole rules will be there. Right now, we're only including laws that have already been enacted and are on the books in that state. In the future, we're hoping to expand to include pending legislation, which is legislation that has not been enacted. It's not the law yet, but it's proposed. That will come in the future. We will be releasing the database in stages over the next month or so. Today, we are launching the pages for Alabama, Arkansas, Connecticut, Georgia, Illinois, Kansas, Maine, Michigan, Missouri, and Nevada. The rest of the states, as well as the category search, will be released over the next month. If you know of any laws that relate to these issues that you don't see in our database, please let us know. That doesn't mean that they don't exist. We want it to be as comprehensive as possible, and we've really searched for every law that we can find, but I'm sure there are more out there, so please let us know. Okay, and then we have also surveyed some state legislation that's currently pending as part of our state policy push. We found some that are of interest to our population and our community. These are not laws. Again, these are proposed laws that are currently pending in the state legislature, so the state house or senate or whatever their equivalent is. They have to be passed before going into effect, or they won't be passed and they will die and not become law. But these are things that you can make an impact in now, because these are things that are currently going. You can have an impact in it by working with your local or state chapter of the ARC to advocate for changes as you see fit. So these are 3 of the pending laws that we found. The West Kleiner Fair Interview Act is currently pending in Florida, and what it would do would be to allow a mandatory someone familiar with special needs of people with Asperger's or autism spectrum disorder or other related developmental disabilities. It would require that they are provided with either a psychologist, psychiatrist, parent, special ed teacher, someone familiar with the disability and how to approach someone with that disability, is with the police for any and all communications with police, whether the person is a suspect, offender, or a victim, no matter what the interaction is. An act relative to criminal justice training regarding autistic persons is pending in Massachusetts, which would mandate police training on autism spectrum disorder and how to interact with victims or offenders with autism spectrum disorder. And then lastly, in Connecticut, they're floating around the idea of a 2-hour mandatory police mental health training, which also addresses developmental disabilities. So those are just 3 of the many, many state statutes that are currently out there being considered. We're not endorsing any of these bills. We're just showing you that they're out there, and these are things that you can get involved in and make your opinions known. You can find these bills and more on your state's legislative website. If you need help finding them, please let us know. I'd be more than happy to point you in the right direction. Your state or local chapter would also have more information about what's going on in your specific state. So now we will get to the first presentation. The first presentation is Maggie Comboy, Diana Goldberg, Carol O'Shea, and Darla Stewart. Marguerite Maggie Comboy has spent a significant part of her career working with victims of crime. She joined the Denver District Attorney's Office in 2003 and is currently a Chief Deputy District Attorney. Ms. Comboy worked under a federal grant to better the prosecution of non-stranger sexual assaults. Ms. Comboy started a specialized sexual assault intake unit with the goal of ensuring the best practices for sexual assault investigations. From 2012 to 2015, Ms. Comboy supervised the Family Violence Unit, a specialized unit which prosecutes sexual assaults on children and felony domestic violence cases. Diana Goldberg has been the Executive Director of Sungate Kids since 1996. Sungate Kids is a children's advocacy organization that provides forensic interview support. Diana has been pivotal in building Sungate Kids' staff into a competent and dedicated team of professionals, as well as overseeing and directing the growth and development of Sungate Kids' many programs and services. Diana is a graduate of Columbia University and the University of Virginia School of Law. Carol O'Shea is the Aurora Police Department Victim Services Supervisor. Carol oversees the Law Enforcement Victim Services Program and supports victims of crime, including those with disabilities. She co-hosts trainings by out-of-state experts with the Arc of Aurora. She hosts the Arc of Aurora staff to train her staff. She co-presents at conferences and other trainings with the Arc of Aurora. Carol embraces the work necessary to support victims with developmental disabilities, and she does that work. Carol's support included assisting with multiple victims of the Aurora Theater shooting. And lastly, Darla Stewart is the Executive Director of the Arc of Aurora and has been involved in the Arc for more than 25 years. Throughout her tenure at the Arc of Aurora, she has led local, state, regional, and national projects improving the lives of people with developmental disabilities. Ms. Stewart served as project supervisor for 2 DOJ Office of Victims of Crime projects. Under Ms. Stewart's leadership, the Arc of Aurora has hosted multiple statewide trainings focusing on creating understanding and collaboration between disability and victim assistance organizations on the impact of violence against people with developmental disabilities. Most recently, Darla is working on supporting local implementation of legislative mandatory reporting of crimes committed against those with developmental disabilities. And with that, I will turn it over to Darla and the rest of her Colorado team. Thank you.
Hello, everyone.
We can hear you, Darla, but we don't see you.
Okay, great. Well, then I'll go ahead and move forward. There we go. Perfect.
There you are.
Great. Thank you, everyone. We have 3 of the 4 presenters in my office today, so you're going to see us kind of move the computer back and forth. No, that's our technical way of giving you the opportunity to see each of us as we present. So thank you for participating and trying to move the slide. Sorry, here we go. Great. So first of all, we just wanted to take a moment to recognize that many Americans with disabilities will expect to be victims of crimes and likely to be victims of multiple crimes. And oftentimes what they don't expect is access to justice. But it doesn't have to be that way. The hearsay exception we're going to speak about today was passed in Colorado. Doesn't guarantee access to justice, but it certainly will make a difference, and you'll have an opportunity to hear about why. So we wanted to make sure that we touched upon the training objectives. It's important for us to provide you all with the opportunity to understand what a hearsay exception is, what is a forensic interview, why it makes it a difference, why it's important for people with developmental disabilities, and why you should at least consider starting somewhat of a collaboration in your state and looking towards creating that as an opportunity. And so with this, I'm going to do that technical slide I was talking about and move this over to Maggie, and she's going to go ahead and get started.
Hello. It's a privilege and an honor to be here. In about, I think it was 2012, I was assigned a case through the Denver District Attorney's Office involving a 24-year-old woman who had both intellectual and developmental disabilities, and she had been sexually assaulted by a coworker in a elderly care facility where they both worked. It had taken him all of 5 days to target her. He had only worked there 5 days when he had sexually assaulted her. It was a difficult case from the start, but it was a righteous case. And he had taken her to the home of a friend. And so she was, while she gave us a scene description, when they went out and found the location, it didn't match the description because, of course, she had described what was the friend's apartment and not his apartment. And we did have some hurdles to get over. But what we had that was a wonderful piece of evidence was a very compelling forensic interview that she had given to police, and that is a recorded interview, in which she described in great detail all of the things that he had done to her. The problem was that at the time we had filed the case, a forensic interview would not have been admissible with an adult victim under Colorado law. We did have what was called a hearsay exception for statements made by children, and I'll back up a second and explain to you what hearsay is. But a hearsay is an out-of-court statement that is offered for the truth. So, for example, if two people are riding in a car together and they get T-boned by another car and someone said that light was green, the person that said the light was green needs to come into court so that they can be cross-examined. And that is comports with our notion of the confrontation rights of the United States Constitution. However, we do have an exception, an old exception, it's been around for a long time, for children's statements describing sexual abuse or child abuse. The thought being that predators prey on some of our most vulnerable citizens, children, and that oftentimes those kind of crimes occur under circumstances where the child and the perpetrator are alone. And I'm not drawing any parallels necessarily between people with intellectual and developmental disabilities, except for to say that, like children, they are they are more vulnerable and they're subject to being victimized, and certainly can find themselves in much more vulnerable situations. And so we got together as a team, and this was a case in which collaboration and multi-agency working together was at its very finest. And so I had met up with Darla Stewart and the rest of our team through trainings involving people with intellectual and developmental disabilities. We had identified that we wanted to get some kind of a hearsay exception put in place for people, adults with intellectual and developmental disabilities. And so we were lucky enough, and all of the stars lined up, where we found a representative, Rhonda Fields, who was willing to sponsor the bill. And during the pendency of my case, Governor Hickenlooper signed this bill into law. And the law is, for anybody out there who does have legal training, I didn't mean to be speaking down by explaining hearsay, but it's at Colorado Revised Statute 1325-129.5, and it mirrors the child hearsay statute, which is just one statute before. And actually, it was written a little bit more broadly, but essentially allows when an individual with an intellectual and or developmental disability has been victimized, statements describing that victimization, or if they've witnessed victimization of another, are admissible in court. That law got signed into by the governor, and in the midst of all of this, my court had originally denied us a request to present our victim's statement because the judge was very kind but said, I don't have any legal mechanism whereby I can do this. We had even tried under what's called the Colorado's residual hearsay exception. But at the end of the day, the defense had asked for a continuance of the trial. And then in the middle of all this, the law got signed. And so we took another run at the court. We asked the judge if he would reconsider. He did. And so the case went to trial actually a couple months after this hearsay exception became law. We used it and were able to play the video statement. And the beauty of all that from a trial standpoint is I actually was able to play it before our victim testified. And so if you consider the thought that before she even took the stand, the jury got to hear this fantastic recorded statement she had made within a day or two, actually it was a weekend after she had been sexually assaulted, and the details were so rich and so they just came to life for the jury. And consequently, by the time she took the stand, the jury was really predisposed towards hearing her and listening to her, and she was nervous. And it was a difficult cross-examination, but the fact was the jury had already heard her tape, and you can't cross-examine the tape. And so it was just a wonderful turn of events that this law got passed and we got to use it at trial. And he did get convicted, and he's serving an indeterminate to life sentence now in the Colorado Department of Corrections. So my time is limited, and I just want to say that the message that I would like to give is working together with different agencies and communication and identifying problems and realizing that if something's not right in your state, and, you know, if you can get the momentum and find the right people to help and to support, and it's a group effort, it's a team effort, but at the end of the day, we got justice not only in our one case, but also for future victims of sexual assault or other kinds of sex crimes that individuals that have intellectual or developmental disabilities. We have this law in place. So anyway, we are here and available to answer questions if anyone has any. Thank you. I turn this over to Diana. Sorry. Sorry for my awkward here. And here is my slide. I'll pass that on, although I kind of explained it.
In the office, Darla. So I hope everyone can see me and hear me all right. And I was introduced already, so you guys know that I'm the director of Sungate Kids, which is the Children's Advocacy Center. The Children's Advocacy Center movement started about 25 years ago with one advocacy center in Huntsville, Alabama, and we are now 800 strong throughout the country, 15 here in Colorado. The idea behind a Children's Advocacy Center is twofold. One, it is to provide children with a safe, neutral place where they can tell what has happened to them and tell it to people who are trained in how to talk to them and how to hear them. But the second part of the concept is that it makes for a stronger case because it pulls everyone together in the case on the front end. So it's our responsibility when a case is brought to us to make sure that all the players who are involved in the case are there to work on it together. So law enforcement, Department of Human Services, District Attorney's Office, and any advocates that might need to be there as well. A couple of years ago, Darla Stewart with the Arc of Aurora approached us to do some cross-training, and Again, as Maggie correctly pointed out, it's not because people with intellectual and developmental disabilities are like children, but rather that they are a vulnerable population, and one that has traditionally been looked at as not making believable witnesses. And we really wanted to change that perception. Children make great witnesses, and people with intellectual and developmental disabilities can make great witnesses as well. But the important thing is how we gather those statements and how we support them in making those statements. And so we embarked on this journey to do some cross-training whereby our forensic interviewers would be trained in how best to talk to people with intellectual and developmental disabilities, how to make accommodations for them, what to do, and more importantly, in some cases, what not to do, in the same way that we work with children. And on the flip side, we wanted to work with the Arc of Aurora to talk about recognition of sexual abuse, physical abuse, neglect, those kinds of issues, and to talk about the system, what happens next, what happens when people in these vulnerable populations are victimized. And so that's how we began our partnership, and of course then it grew into working together on this legislation. And as Maggie also mentioned, there is a child hearsay exception for forensic interviews of children. These interviews are critically important, both because of what the children are able to disclose and also because of the way in which that information is obtained. One of the critical pieces of a forensic interview is that the interviewer does not ask leading questions. We can ask direct questions, but we are very, very careful not to ask leading questions. And the reason that we have our own forensic interviewers on staff is because law enforcement and human services agencies don't always have the resources to have their own people trained in how to conduct these kinds of interviews appropriately. And so it's our responsibility to make sure that our interviewers are highly trained, that they have continuing education, that they're privy to the most recent literature and training and you know, all the recent developments in forensic interviewing. And so our interviewers can interview a child as young as 2.5, depending on their verbal skills, all the way up to the oldest person we've interviewed was actually a case through the Arc of Aurora, 64-year-old woman with intellectual and developmental disabilities. Now, obviously, we follow a sort of what we call a relaxed protocol in how we interview people. And so there's a certain method to how we do it, but we do make exceptions and we do make accommodations for individual needs. So for instance, for younger children, we understand that they can't sit in a chair and talk one-on-one, that they need to be moving around. And so that's something that we take into account when we're interviewing young children. By the same token, we understand that some folks may need language assistance. They may need to have their advocate in the room with them when we're talking about adults with intellectual and developmental disabilities. They may need to have other kinds of accommodations. It becomes our responsibility when we're conducting a forensic interview to make sure that we have all of that information before that victim ever walks into the interview room so that we can help them have the best interview experience possible, and so that we, as child abuse professionals, on the other hand, can get the most information that we can get. And so it really is only through that kind of a partnership with our local ARC organization that we were able to actually gain this kind of insight, gain this kind of expertise, and be able to do these interviews effectively. It's been a tremendous boon for us to be able to accommodate those victims. Our abiding principle is that we never turn a victim away. And so we never want to turn a victim away because they are over 18 or because they have an intellectual and developmental disability, or because of any other circumstance. But we also don't want to conduct an interview that would be inappropriate. And so by having this partnership, we're able to balance those two competing concerns. I think that about covers what I wanted to talk about, so I will turn it back over to Darla unless I'm missing something. And I expect Darla will tell me if I am.
Carol. Okay, I think it's my turn. This is Carol. Can you hear me?
We can hear you, Carol.
Okay, thank you. So I'm with the Victim Services Unit with the Aurora Police Department. I'm very pleased to be a part of this conversation. We have made so much progress. I think originally what we faced on these issues was kind of overwhelming and seemed insurmountable. It felt like any time we met with a victim with an attempt to take a report, we certainly were probably not getting the information that we needed to move it forward within the system, and most definitely, trying to find the slide here, sorry, okay. Most definitely probably not serving our victims with dignity and respect in every means. Without that intention, what I think we realized is the most powerful thing to recognize for us from the law enforcement perspective is the very disability that makes these victims vulnerable also presents the barriers within the system for us to move forward in taking the information. And from the law enforcement officer, the first responding patrol officer, and getting enough information to move on to a detective, and then certainly from an advocacy perspective to advocate that victim's voice would be heard throughout the system, and for that voice to be heard. We're getting a little notice here, hold on. Okay. So I think one of the things that we were trying to overcome were the credibility and capacity issues that we have decided can be reduced in training and awareness with the officers. And so we've taken on that responsibility as a law enforcement agency, that we from the very front end and first point of contact have to be the ones to set the tone. So we have worked hard. It can be a bit, it can be overwhelming to the officers, and the more we talk about it, the more exposed they are to this population, the more comfortable people become. So I would say we've been at it about 8 years, I believe, and I think we're getting there, and we see the progress, and we have formed in the Aurora Police Department a special victim unit, which is going to include the investigations of these cases as well as our elder abuse cases, which currently is state mandated report. We have state mandated reporting on elder abuse, and as of July in 2016, we'll have state mandated reporting on people with intellectual disabilities. So we're trying to prepare for this. I think the biggest lesson we've learned is that as hard as we try, not one entity of this collaboration can really make a difference without the other, and the expertise that is brought to the table with ideas that I don't think any of us would have considered alone. And the fact that we pulled through with the hearsay exception gave us all just a little more oomph, and I think commitment. When we talk about victims' rights, and we talk about underserved populations, this is actually #1 in my book. And the number of cases that move forward and access to justice for these victims is much, much lower than it should be. So we have, obviously, to make that commitment. I think we also have decided that training certain units and certain groups of responding officers has also made an impact. They become a resource for other officers, and this is really how we're making a difference within our patrol and our with the frontline officers, is having access to asking questions. And we, with the assistance of the Arc of Aurora, we have created videos that every officer has had the opportunity to view and access that tests their knowledge about this, but also, you know, what if, what do I do? And the biggest lesson I think they've learned and what they will express to us is just slow it down. And in the world of law enforcement, that's not necessarily how they operate. So that has taken some shifting of gears. But I think we notice that the interactions with the Arc of Aurora and other agencies and other, just Metro-wide, the support that we bring for one another has really made the difference to move this forward.
Great. We're going to do that technical slide again. So this is Darla, and I'm going to try to close it out with a couple of important points. One of the questions that folks might ask is, well, why is this really relevant to people with developmental disabilities? And I think you've heard great explanations from the previous speakers. I wanted to talk a little bit about how most crimes committed against people with intellectual and developmental disabilities are categorized. They're categorized as crimes against the person. Means that they're not really things that deal with, you know, stealing my car because I don't have a car. Typically, they're crimes committed against the person, as an assault 3 times higher, sexual assault 11 times higher, and robbery is 13 times higher. And the reason those crimes against the person are so much higher and people with intellectual and developmental disabilities are more vulnerable is because perpetrators think they can get away with it. And oftentimes they do. They get away with it because law enforcement and prosecutors really are challenged with how to make sure that the victim is seen as credible. Because these crimes are often he said, she said, witness, you know, reliable witness expectations. So I think the hearsay exception allows, if the judge recognizes it as so, that the jury sees a taped forensic interview. And I think you've heard about why all of that is so important, to use people who are specifically trained to make sure that they don't ask leading questions. It's not as if you and I could get in front of a camera with an alleged victim and have a discussion and have that be introduced. That's not the type of introduction video we're talking about. We're talking about with trained professionals who would then sit on the stand and say, this is my background, this is my experience, and this is why I think what this victim has provided is credible to the best of their capacity. So I think that's why it makes a difference. I think you've heard a little bit about why we in our community have been so happy to work collaboratively together. So strategies to replicate. I think it's important to recognize that, as you've heard, that we all knew each other before we started this discussion. We knew each other from trainings, we knew each other from discussions, and we trusted each other. So if you want to replicate, the first part is to use some of the great work that's coming out of ArcUS to reach out to your local law enforcement, your district attorneys, your community at large, and say, can we talk about certain things? Can we educate you about the population? Can we talk about incidence and prevalence? Are you experiencing crimes that are committed but frustrated by the lack of prosecution? There are lots of reasons to reach out. You probably have more in common than you recognize. And cross-training is critical. So the first part is to really look at a collaborative effort and make sure that you identify specifically and deliberatively who you want to participate in that collaboration. I know a few years back, Jean from here and myself and Leanne went around the country and we talked about how to create that collaborative. You know, so there are tools to do that. The one thing about the collaborative discussion that's critical is to make sure that the people at the table can make the decision to move forward on the next step. Training is one thing, but if you're going to look at replicating the efforts that we had, you have to have a group at the table who has the authority to say, yes, let's move forward with a piece of legislation. The other piece is to identify an appropriate legislator. We were lucky. Representative Rhonda Fields out of Aurora has a strong victim background. She clearly understands the issue of victimization. So she was happy to carry the legislation. And what Representative Fields also brought to that discussion was a strong respect with law enforcement and the prosecuting community on the statewide level. She had carried previous bills for them. They knew she was reliable, and she had connections to reach out to them too. So even though this was a local discussion, when Representative Fields was willing to carry the legislation and it was actually drafted, she had her own connections to reach out to that law enforcement and prosecution lobbying community to get their buy-in, probably something none of us at the local level had. So again, when you're looking at that coalition, when you've got that team is now comfortable in with moving forward with something like a hearsay exception, and you get that legislator, having somebody who has that strong victim background and strong relationships is critical. The other thing that we thought was really, really important was to make sure that the discussion wasn't just about people with intellectual and developmental disabilities, but involved people, victims of crime and their families who were willing to testify and speak about the experience, because that's who we were talking, whose lives needed to be changed, who needed to know that they had access to justice. Specifically, we had a couple of folks, and then Representative Fields, when she announced the legislation, had a couple of folks who came forward and said, we, our family member, we've been a victim, we want to talk about this too. And that leads me into the final part of kind of that formula to replicate, which is make sure that you have the opportunity to involve the press and do so deliberatively. I mean, this whole process required somebody managing behind the scenes. That was kind of my role. I was telling folks, you're going to go first, you're going to go second, here's how we're going to have that testimony work. But behind the scenes also was reaching out to press and saying, this is really compelling. These stories are compelling. This information is compelling. And so we had that component that was supporting our outreach. Now, I want you to know that we had some pretty strong opposition. It wasn't a lot of vocal public opposition, but the defense bar had a really strong hold on the legislative committee that we were going to be presenting to. And it was a huge upfield battle. I think we only had one person testify against the bill. We had 10 people testify in support of the bill with this broad array and collaboration, but the defense bar had been really strategic and behind the scenes lobbying. So having the press at that event made this really a hot issue, a very public issue. And I think if we hadn't had the press involved, we might have seen this bill die and us need to come back another time. So I think don't underestimate opposition, and even opposition that won't publicly talk to you about it, but will show up at the end. And with that, I wanted to give you the opportunity to look at more information. One of the things that we did was we kept a Google site open when we were passing it. It was House Bill 1085. So you can actually go to this Google site. It will give you all the pieces of news stories that came out about the bill, the fact sheets, and the actual legislation. And with that, I think we're close to our 30 minutes. We'll hang around and look forward to having an opportunity to answer your questions. Thank you so much.
Thank you, Darla. Maggie, Diana, Carol, we appreciate you guys, your great presentation. Just a reminder before we get to the next presentation that there will be, a question and answer section at the end of this session. So please be typing in your questions in the Q&A box or the chat box. And now I will turn it over to Patty Saylor and Heather Sachs. If you guys could turn on your video while I introduce you. Patty Saylor is the proud mother of 3 young adult children, Emma, Adam, and the late Ethan Saylor. She has been an advocate for most of her life. In 1987, shortly after Ethan was born, Patty founded Friends, the Family Resource Information and Education Network for Down syndrome. And she is a registered nurse and eventually earned a master's degree in special education from Johns Hopkins University. Patty has served on numerous work groups, committees, and boards, all dealing with an effort to increase awareness and acceptance of individuals with intellectual and developmental disabilities. Patty is currently the owner of HealthBlink LLC, which provides nursing case management for adults with disabilities who choose to live in their own homes and self-direct their own services with the support of the significant people in their lives. Patty and her family were and continue to be tireless advocates for their beloved son, Ethan. She was instrumental in creating a new mandatory 4-hour training on intellectual and developmental disabilities for police recruits in Maryland that is taught by self-advocates. Heather Sachs is the Vice President of Advocacy and Public Policy for the National Down Syndrome Society. She spearheads all federal, state, and local policy initiatives on behalf of NDSS. Heather has been one of the national leaders in coordinating the passage of State Achieving a Better Life Experience, or ABLE, Act bills to establish a savings mechanism for people with disabilities, and is now working with legislators, financial industry leaders, and state treasurers' offices on ABLE program design. Heather has nearly a decade of experience doing advocacy work in the disability community. She received her BA from the University of Pennsylvania and JD from Columbia University School of Law, and she is a member of the District of Columbia Bar. She lives in Potomac, Maryland, with her husband and 3 children, one of whom happens to have Down syndrome. And now I will turn it over to Patty and Heather.
Well, hi. Thanks, everybody, for attending our webinar and giving us a chance to let you know what we've been doing here in Maryland. As you know, I am the mom of Ethan Saylor. That's kind of one of my greatest accomplishments, along with my 2 other adult children. Most of you know Ethan's story, but let me give you a little update or background, I guess. On January 12th of 2013, my son Ethan was attending a movie in our local movie theater, and with his support staff. And you know, he liked the movie a lot and did not want to leave. And at that point, he did not have a ticket for the second showing. So the theater manager called the security, who happened to be the off-duty law enforcement officers. And in their attempt to encourage Ethan to leave, you know, we believe that they did not truly understand or value him, and it escalated quickly to their use of force to physically remove him. And he lost his life on the floor of that movie theater. From the medical examiner's report indicated positional asphyxia. So, you know, of course, that was the worst tragedy we had ever experienced in our life, and we really felt devastated and felt that something needed to be done. So what happened? So we could go to the, you know, grassroots advocacy. I happen to be well connected in the state to a lot of advocates and a lot of other parents of kids with disabilities, not just Down syndrome. And immediately my friends and colleagues wanted to get together and say, what can we do? What can we do to make sure this doesn't happen again? There was a movement across the country that was fueled by the outrage that parents and advocates felt that how could this possibly happen? We formed what we called the Ethan Saylor Work Group. It was the very first name of it was the Restraint Work Group, because we knew that something, you know, he died because he was restrained. And my friends pulled that group together, and slowly we pulled in people from our state that wanted to be involved, you know, and this was purely voluntary, and self-advocates and leading self-advocates in the state participated in Ethan's Law Work Group. And we began to formulate our goals. And our goals at that point were a non-negotiable, which would be police training that included self-advocates as involved members of the training. Any training would be cross-disability. It wouldn't be disability-specific. We felt there needed to be a mandate so that this actually happened. And we continued to meet to formulate our plan of action. Again, this was voluntary. It was really just people motivated out of tragedy. And many people that met did know Ethan and certainly knew me. So during that time that Ethan's Law Work Group began meeting, the social media outrage grew and grew. And we were getting support from all over the world, actually. My daughter, at that point, started a change.org petition. Our initial call was for the governor of Maryland to launch an investigation because we did not feel Ethan's death was investigated properly, that he was not given, it was not given enough attention. There was certainly a grand jury hearing. The officers were not indicted on any criminal charges, and the officers were not even placed on administrative leave or had any consequences at that time. So the initial push was to have an investigation. So my daughter's change.org petition garnered almost 400,000 signatures from within Maryland and across the country. We went to Annapolis to present those hard copy petitions to the governor, and with that, we made enough noise that he granted us a meeting. So he met with my family, you know, Ethan's dad and brother and sister and I, and out of that meeting, he felt compelled to do something. Although he was clear that he did not feel that he could authorize yet another investigation, because at the time there was the grand jury investigation, the internal investigation from the police force, the investigation into his death, and we were told that there was a Department of Justice investigation underway. So he did not feel that he could authorize yet another investigation. But what he did was to issue an executive order. And that executive order names Ethan and what happened to him. And this executive order established the Commission for the Effective Community Inclusion of People with Intellectual and Developmental Disabilities. And the governor had asked Tim Shriver of Special Olympics if he would chair this commission. And Tim got in touch with myself and my family and asked if we wanted him to do that. And we said yes, of course. And the commission began their work. And the commission was made up of people from law enforcement and from the disability community and self-advocates and other state officials. And they worked tirelessly together. It was the most beautiful thing to watch, this collaboration of people who really had a central goal to make something different. The head of the state police at that time told me that when he heard of Ethan's death, he knew he had to do something about this, that something had to change, that people would not be at risk. And so the commission did great work, and the training commission, the subcommittee of this particular commission came up with some recommendations. I think there'll be a link to that commission if you wanted to see some of the minutes and some of the meeting recommendations and such. During that year-long, or about a year and a half work of that commission, through our collaboration with law enforcement, we came to realize that the state has a police training commission, and I believe there's some type of entity in every state similar to that the police training commission will set the standards for all police training in the state. And working with this commission, the police commission, they asked us if we would not do the legislative route, but that we could get what we wanted in the way of training and mandatory training and the inclusion of self-advocates if we worked with them to implement training objectives. And if the police commission adopted those training objectives, they would in fact be mandatory in the yearly or annual training requirements for all officers in the state. So we did work with them, and through that regulatory process, the Maryland Police Training Commission adopted an extensive set of training objectives. The first focus was to, an easier one, and that was to focus on the cadets in academy. It's kind of a captive audience. They know how many cadets they're going to do, how many trainings they're going to be, and they could implement that fairly easily and quickly. So January of 2015, the mandate for the training objectives around interacting with people with intellectual and developmental disabilities went into effect for all academies. In our small state of Maryland, we have 19 police academies. And so each one of those police academies then had to figure out how they were going to implement that. Part of the work of the Governor's Commission was to work on that curriculum and develop a curriculum. And we've been certainly in contact with USARC and many other places around the country that are doing training and put together pieces that we thought were applicable in Maryland. So we really designed an 8-hour training for the academy level. And that has been happening for over a year now. And the second piece of that, through the regulatory of time. So as of this past October, which would have been October of 15, the state police, not state police, but the Maryland Police Training Commission adopted mandatory objectives for in-service officers. And that requires a 4-hour training be implemented for all officers that are in service over the next year. And that became effective January of 2016. So as of very recently, the in-service trainings are going on. Now, the theme that is very exciting about what we're doing here in Maryland is from the very first meeting of Ethan's law work group, a group of colleagues and friends that were in pain and in mourning for Ethan, that theme started there, that nothing would happen without self-advocates leading the way. And that theme carried through the work of the Governor's Commission. We were able to see during the work of the Commission, watch law enforcement, the light bulbs go off in law enforcement personnel's head about how this actually worked, and that self-advocates were valuable and had great input and could in fact participate as co-trainers. And so they were skeptical but agreed to go along with us. And we really saw how they learned and how they understood. And now they are very much advocates as well that self-advocates be involved in all the training. But it became painfully clear to us through this whole process that there was no infrastructure for preparing and supporting and paying self-advocates who were interested in this line of work to be co-trainers. So that brought us to the need to build the workforce. And I'll turn it over to Heather, and she can talk to you some about how we went the legislative track on that need. Thanks. Heather, are you ready?
Yes, thank you, Patty, and hello, everyone. As Patty explained, it became apparent that we were not going to have to introduce a bill to mandate law enforcement training. We were lucky enough that our law enforcement officials who were participating on the commission and in the work group saw the value to this and were able to put the training into their mandatory curriculum without legislation. But what did become clear, though, was that we needed some type of legislation to ensure that there was a training mechanism for these self-advocates. Initially, the bill that was drafted, that we started advocating for, and again, this is in Maryland, in Annapolis, last year during their legislative session, was going to form an Ethan Thaler Center for training self-advocates as educators. The idea was that it would actually be, you know, a geographical location in a Maryland university center on a campus. You know, it would have staff, and it would be a training center. Unfortunately, though, it, you know, became pretty clear that we were not going to be able to get the funding and the infrastructure for that. So as often as happens, you know, during the legislative process, especially during state legislative processes when the sessions are so short, is we had to scale back the bill. So, you know, that would be my number one piece of advice, that, you know, even if you can't get what you originally are going for, you take what you can get as long as it's an improvement, realizing that you can always come back for more. So we ultimately scaled back the bill such that what was formed by the bill, and I'll get to that on the next slide, was the Ethan Saylor Alliance for Self-Advocates as Educators. It does not have a physical residence. It is not located in the university. What it is a framework and program, essentially, run out of the State Department of Disabilities that will provide training mechanisms for self-advocates as educators. A lot of it will be done in the local communities. And the idea is that when a local police agency or, you know, first responder force wants to do this type of training, they would engage a self-advocate from their own community and not someone from across the state, because it is so important that they make those personal connections with the advocates in their own community. So, you know, the bill changed as it went through the process, as it often does. Now, we also had to identify legislative sponsors. And in our case, because, you know, Ethan's tragedy had happened in Frederick County, Maryland, of course, we went to the Frederick County delegation first. They were very supportive. This was something that happened in their backyard, and, you know, they knew Patty, and she was a constituent, and this was something that, you know, became very important to them, and they led that. And it was very important for us to get the entire Frederick County delegation on board, which we did. If you don't have that type of geographic connection, though, I would actually recommend looking for connections to the disability community from both the members or also from their staff. I remember we had a meeting with, you know, a staffer for one of the Maryland delegates, and it turned out that, you know, she had a nephew with Down syndrome, and we never knew that. So, you know, if you can kind of put your feelers out, you know, in the community and see who has direct ties to the disability community where this will be most impactful for them. And like all initiatives, it's very important to get bipartisan support on this. As Patty explained, there was a big grassroots advocacy effort that that was, you know, organized around the Ethan Saylor Alliance bill. We made sure that it was a cross-disability effort, even though it was being led by the Down syndrome community. It was very important that we include, you know, the autism community, you know, mental health groups. So, you know, it is a cross-disability effort, and as Patty said, the training should not be disability specific. What was very important always and continues to be is to have self-advocate participation in all of the meetings, all of the hearings, and all of the testimony. The self-advocate voice is the most powerful voice. It also became very important to engage the advocacy leaders on both local, state, and national levels. So, you know, for example, with for the Down syndrome community, the local affiliate groups in each community, then there's a state-level advocacy group, and then obviously the National Down Syndrome Society and the National Down Syndrome Congress were also very supportive. And I know that, you know, through the ARC, they were very supportive in this legislation, the Maryland ARC as well. And, you know, this is the type of thing that should really hit all levels of a particular group. It's very important, too, to enlist the help of law enforcement and first responders in advocating for the bill. It's not enough that they're just going to say, okay, you know, we're not going to block this bill, that we see the value to it. But it became very important that where possible, we had law enforcement officers go with us to meetings with delegates We had them testify at the hearings and say that, you know, they need this bill. They want to do this training. They want to utilize self-advocates in meaningful roles. They just don't know how to do that. And this bill would really give them the tools and resources that they needed to do that. Okay, so as I said, there's a picture of our bill signing. It's a little squished. So the bill which passed last year was the Ethan Saylor Alliance for Self-Advocates as Educators. It has been established in the state government arm, the Department of Disability. That's actually a cabinet-level position in Maryland. And the central premise of it is nothing about us without us. I know we've all heard that before. The self-advocates are going to be prepared, supported, and compensated to participate as co-leaders in local law enforcement and other public entity trainings. And as Patty mentioned, there's a great curriculum that's been developed for this. And the Saylor Alliance has recently been funded and has been meeting and planning all of this infrastructure. And the great thing is the self-advocates will be compensated for their time. So this is not a volunteer position. This is actually something that they will make money doing as they're providing a very valuable service for the community. So after the bill passed, our work clearly was not done. We have continued to advocate for implementation of the bill. It actually took the governor a while to fund it. Unfortunately, he only had funded the first year, not 5 as requested, but the funding that he did give was enough to start it up. I believe it was $25,000. It was also a challenge because the people that had served on the commission for the effective inclusion of individuals with intellectual disabilities were not automatically rolled over onto the Saylor Alliance Board. And so you had some experienced people on the Saylor Alliance Board that were on the commission, but then you have quite a few new people as well. So these are people that need to be educated on the topic and best practices, and there's always time to get people up to speed. Another thing that you can do to make sure that something like this is implemented after it passes legislatively is to really scrutinize the local training programs. And this, this actually could tell you in a certain state, whether or not you could need to bring such type of legislation. The self-advocates must play a key role in these training programs, and it would definitely be helpful to suggest best practices. And I'll talk about that in a minute because there actually may be best practices resources out there that are being developed right now. It's great to demonstrate success and collect data. I know that that's a difficult thing to do, and how do you define success? But I think that, something that's very telling would be interviews with law enforcement folks on, how they are handling, certain situations when they encounter people with disabilities. Also in the disability community, it's definitely becomes pretty, commonplace now in Maryland to see law enforcement officials routinely attend many of our disability group events, such as our Buddy Walk and, any type of public awareness event. And it's making those key relationships, which I think are also improving interactions in addition to a formalized training program. It's helpful to expand this concept to other states. And we're in the process, the National Down Syndrome Society is in the process of developing a toolkit to bring this type of legislation in other states. And, please reach out to me if you would like those resources. I'm sure we can also work with the ARC on this, and they've probably done a lot of work in this area as well regarding developing toolkits. I know that they've done a lot in the law enforcement training area. And then it's important to continue advocacy at a national level. I'm happy to report that the Department of Justice reached out about a month ago. They are in the process of forming a whole work group to develop a best practices training program for law enforcement officials and first responders to interact with the disability community. They've pulled in a lot of different stakeholders, including the law enforcement voice, including the self-advocate voice, which is so important. And, you know, I anticipate that these resources are going to be ready sometime by summer or fall. And, you know, I think it will be great to have a program that is endorsed by DOJ, you know, to be able to give, especially to localities that have not done any of this type of training before, where they're just very overwhelmed and they don't know where to start. So, so look for that on the horizon. And with that, I open it up. I'm going to send it back to Ashley, and then I would be happy to answer any questions.
Thank you so much, Heather and Patty. We really appreciate both of the presentations that we had today. And now I'm going to open it up for questions. Please be ready, put your questions in the Q&A box. I know that the presenters really want to hear from you. We have a few questions already. Presenters, if I'm just going to put the question out there, and if you have an answer to it, you can go ahead and just unmute yourself and answer the question. So the first question is for the Colorado team. Does the definition of developmental disability in Colorado include those with FASD? Can this process be used on behalf of a defendant with similar problems?
Ashley, could you repeat that? I'm sorry, we were kind of maneuvering around the table.
Not a problem.
To make sure
does the definition of developmental disability in Colorado include those with FASD? And can this process be used on behalf of a defendant with similar problems?
In defense of a case as opposed to the individual being a victim, I'm going to go ahead and have our legal person answer that. Regarding the definition, I would simply say that Colorado recognizes two ways that a developmental disability is manifested or is identified. One has to do with an IQ, and the other one primarily has to do with activities of daily living and capacity to function in that realm. So I'm assuming for most people with FAS or FASD that they would qualify under that definition. So I'm going to have Maggie now speak to the issue of using it as a part of a defense as opposed to prosecuting a case.
In any case that we prosecute, we have to establish not only what we call the mens rea, which is to say that the act took place, but we also, or the actus rea, that the act took place, but we also have to establish the mental state. In many of the crimes we've been talking about today, the sex crimes, the mental state in Colorado is knowingly. And so the question of whether or not a defendant knowingly committed a particular act would be a question that we would probably flesh out long before the case got to a jury. Most often I'll see, you know, and I have to confess not a lot of experience with FAS, but when a defendant has a particular cognitive limitation, sometimes the defense might raise competency, and then there's a whole host of statutory provisions that come into play. But the upshot is the defendant is entitled to have an evaluation done. We are entitled to also have him evaluated. Sometimes, yesterday, in fact, had a contested competency hearing. So it just depends whether or not someone is capable. So the quick answer is, sure, FAS could bear on A, our ability to file a case, B, our ability to go forward to the end of a case.
And I think, though, the question was, would a hearsay exception and the forensic interview be admissible or used to support a defense? I don't believe that the way that it was passed in Colorado, it would provide that level of support. This is Darla.
Yeah, and I apologize. I didn't understand that. Yes, the language of a statute, this is for the victim or someone who has witnessed a crime.
Okay, great. Thank you so much. The next question is, what happens when a person with an intellectual or developmental disability who is nonverbal is engaged with the criminal justice system, either as a victim or a suspect? Do any of you guys have any experience with that? Are there any provisions for allowing the person to speak via augmentative communication, such as iPad communication apps, things like that?
This is the gang from Colorado. Absolutely. I think Diana spoke a little bit about the accommodations that are used during a forensic interview. So whatever is necessary to allow the individual to give voice to what they'd like to share and what they feel is relevant is actively used, at least in respect to the hearsay exception. And you know, the ARCs also work with people who are alleged to have committed crimes, so the ARC of Aurora would absolutely reach out to local law enforcement to support that accommodation as well.
Okay, great. Thank you so much.
Sorry, Ashley, this is Diana in Colorado also. I just want to second what Darla has said. We've actually done forensic interviews with folks who needed to use augmentative equipment. And it's, you know, it's an unusual circumstance, but we've been able to work it out.
Great, thank you. The next question is, I believe, for either team, so whoever wants to jump in here can. While it's great that Maryland law enforcement sought change from within, can we rely on such cooperation from jurisdiction to jurisdiction or state to state? We need law and rules with teeth, enforcement, and consequences. How do we go about that when it seems that everyone is against us? Anyone want to take that one? Don't forget to unmute yourself.
Sure. Carol, do you want to jump in? Carol's our law enforcement representative, so we'll put her on the spot.
Well, I think that I can only speak from our experience, but I do see the challenges in this. From my perspective, I'm not sure it was as much as against the issues or the victims, but not having the tools or the awareness or the training, or maybe even knowing the responsibility we have. In our state, we have a Victims' Rights Act that pretty much mandates us to accommodate victims and to treat them with dignity and respect regardless of disabilities. So that's kind of one of the motivators. But I actually think this requires patience, and I don't think it's something that one round of training can even impact. I think it has to be continual and maybe reinforced. And from what I'm hoping that we're going to see here in Colorado with the mandated reporting is collaboratives within law enforcement agencies that share the training and what's effective and what's working, because we're all kind of right now just trying, trial and error.
Great, thank you.
Ashley, this is Patty.
Hi.
I have to say that from the very beginning with Ethan's Law Work Group and the early positions of people that were on the Governor's Commission, we clearly and strongly wanted mandate and to force people to do what we thought they needed to do. And what we realized over time is through relationship with these folks and having self-advocates involved in building those relationships, that is what softened the hearts of law enforcement. They wanted this training. They wanted better relationships. We didn't have to take them kicking and screaming, although I want everyone to know that's where all the advocates were coming from in the beginning. We clearly were geared up for we're going to have to make them do this with legislative efforts that had teeth in them. And through going towards people and really having personal interaction, we found that we didn't need to do that, and they actually asked us if we would not, to trust. So on both sides, we had to actually trust going forward. And so, yes, we did have a good outcome. It may not certainly be that easy in other states, but it's certainly worth a try to build relationships and go forward.
Great, thank you, Patty. Another question for Patty, actually. How many self-advocates has the Ethan Saylor Alliance been able to recruit? And how many are needed to effectively implement the objectives? Heather, feel free to jump in here as well.
Okay, I'll take a stab at that first. Well, first of all, I have to tell you the Alliance itself has not trained anyone. It's only been in existence, again, the money just became available in the summer. So what I have to tell you is that informally around the state, many people are being trained, and many self-advocates are participating in local training in a kind of very organic way, and the local ARCs have been very helpful with that. We got held up in a lot of bureaucratic red tape in the procurement process, so it's still a new initiative, and we expect that the Alliance will actually be recruiting this summer and preparing folks. So it's been slow to roll out because of some bureaucratic red tape, but I feel like it's kind of birthing a baby here. We're getting ready, and all of a sudden it's going to take off. So people are lined up waiting for advocates to come out of the Alliance.
Great, thank you so much.
Ashley, I wanted to comment on that. This is Leanne again, and Patty, I want to thank you for speaking today and speaking about the issue you just talked about. It's a great situation that everything that's going on in Maryland right now is paralleling what we're doing here at the national level with the National Center on Criminal Justice and Disability, because as you know, many of you probably know of the Pathways to Justice training that we've been piloting for the past 2 years, and seeing how both of these two movements are really coming together. So we've been working very closely with the National Down Syndrome Society and with Patty, and really making sure that our efforts are really joining together into one cause, so that we can get out the training as much as possible to law enforcement, but we also are looking at training lawyers as well as victim advocates. And I'm just really excited about this opportunity to continue working on these issues. And as Patty said, it's really, much of this is a grassroots effort, and we can't legislate attitude change. And so both at the National Center on Criminal Justice and Disability and through our chapter network and through stories like Patty's, we're really able to start seeing change happen at the national level and in small little ways, but growing into more of a national effort. And so any questions that you have about the Pathways to Justice training, you can also contact us regarding that. And we make sure, too, that self-advocates are also involved with any training that happens. That's just critical. That, again, we've seen that too, that the more that we have self-advocates involved, the more that you see attitude change. And it's been our experience too in the trainings that we've provided that officers and attorneys and others, they really want to know this population better. They want to know how to communicate better. So it's a matter of providing them with the tools and the ability to do that. So I just wanted to make sure that, that we get that in there too, because we want to give a balanced approach to this and really come together as a team, whether it's at the national level or on the local and state level, to address these issues.
Absolutely. Thank you so much, Leanne. The next question is, what documents must be presented to provide evidence of a person's disability status? How can a person that is a victim or one being charged communicate that they have a disability? Sometimes that's not an apparent fact.
Hi, this is Maggie. It's a great question because how we go about proving that someone has a disability is really on a case-by-case basis. In the case that I was discussing earlier that led to the processing and passage of this new law, our victim has Down syndrome. And so the statute has a whole laundry list of definitions under Title 27 in Colorado. And so if someone is receiving certain benefits, if they have certain physical qualities, I mean, there's a whole laundry list. And in the case of our victim, we actually also put on an expert to talk a little bit about her intellectual functioning and how she processed information, because at the end of the day, the way we had charged the case, we had to prove to the jury that he had overborne her will. And it wasn't a traditional knockdown, forcible sexual assault, but what it took to for her will to be overborne as an individual who has Down syndrome and who has intellectual and developmental disabilities was a very different matter than what it would take to have your will overborne as someone who didn't have the same limitations. But we have to think about that, at least because for us, I do have to prove that in Colorado. And so I will tell you, there have been times I have charged a simple sex assault as opposed to charging a sex assault against an at-risk adult. Even though the at-risk adult carries a higher degree of felony, I didn't want to open the door to having all of the victim's medical records become at issue with the jury, and more importantly, that the defense could exploit. So we kind of look at a case-by-case basis. I mentioned our original case because the Down syndrome was such an easy thing for us to prove to the jury, and it was such a no-brainer that we could get that box checked and we did not have to go into any medical records. We fight like crazy to keep medical records from a jury or from the courtroom, and usually are almost always successful on that issue because obviously the privilege is something that's sacrosanct. But there might come a time when we need to resort to some medical records to prove certain limitations as set out by the statute. So I know it's a long question, but essentially the answer is you have to look at your particular victim and determine what disability that is as it relates to the statute, and then you have to brainstorm as to how you're going to establish it. And my final postscript is, as a prosecutor, we do everything we can to protect information from being disclosed, abused by the defense.
And this is Carol. I'll just add, from the law enforcement perspective, I know they have to consider that same statute, but I think a key point in the initial stages is also how that impacts communication style, which is where we have used our experts within the disabilities community to help us establish the appropriate form of communication and making sure that we're giving every opportunity for the victim to be able to communicate and for us to be able to establish what that disability is in order to move it on to the courts. So I think, again, that whole collaborative piece, it's not something that's going to just be obvious by interviewing. You're going to need to do some work to really establish that.
Thank you, Maggie and Carol. The last question, we only have a couple minutes left. Quickly, how do you balance the confidentiality of the person with the disability and the requirements of the ADA when preparing the case? Does anyone have any information on how to balance the confidentiality of the person?
I don't want to be redundant, but kind of following up on my last answer, I think it is a delicate line that we walk because, in many of the cases that we try, the defense is going to get nowhere near doctor-patient therapeutic records. They don't get near medical records unless, for example, there's an injury, in which case they can have the records from that particular day to prove that particular injury. But we don't allow the defense to flay or splay open our victims' personal lives in the courtroom. But the fact is, if we're needing to establish because of statute or because I'm trying to charge a higher felony, if I need to establish a cognitive or an intellectual or developmental limitation, there may come a time that we do have to disclose at least portions of a record. I guess my answer for everybody out there would be, you want to work with your prosecution team and you don't willy-nilly disclose. You fight those things out in pretrial motions hearings with the court, and you look to the court to be the gatekeeper in order to limit and severely limit to the defense what's going to be brought in. It's kind of like if I'm trying to get a closed circuit TV for a child, for example, I might have a treating psychiatrist to come in to talk about how communication in front of the defendant in an open court would wreak such emotional hardship on the child that he or she would be unable to effectively communicate in front of the jury. Oh. Well, anyway, likewise, but that you would never open that up to medical.
Great, thank you so much. So we don't have any time for any more questions. I will make sure to forward any questions we do have to the presenters today. Some closing remarks, please, please, please fill out the survey that will pop up when you close WebEx. It really helps us out to know your feedback. If you're interested in our legislative database, please go to our website, www.thearc.org/NCCJD, and you can find our legislative database there under resources. And please be on the lookout for an announcement for our next webinar, which will be focused on issues that attorneys face in representing clients with IDD. We appreciate you all being here today. Thank you again for our presenters, and have a good day.
I think that's it. And she will send us questions, so let's see if we close out.
Yes, Darla?
Yes?
I will send you any questions to follow up.
Okay, great. Great. Well, thank you so much.
Great, thank you.
Okay, bye. Okay. Oops. Leave.